A defense attorney stands up in the middle of a murder trial, looks at the judge, and says 4 words that have never been spoken in that courtroom before. "I cannot defend this man." The judge is stunned. The jury gasps. And the defendant, a man facing the death penalty, watches his only lifeline walk out the door. What could possibly make a lawyer abandon their sworn duty and destroy their own career? The answer is more disturbing than you think. Here's what most people don't understand about criminal defense. Lawyers don't get to choose. When you pass the bar, you take an oath. You swear to defend the accused, guilty or innocent, monster or saint. It's the foundation of the entire justice system. So when a defense attorney walks away from a client, something has gone catastrophically wrong. Either the lawyer discovered something so horrific they physically cannot continue, or the client did something that crossed a line even criminals don't cross. Over the next few minutes, I'm going to show you 7 cases where this exact thing happened. And by the end, you'll understand why the final case on this list made legal history for reasons that will fundamentally change how you think about justice. Case number 1. 1994, Houston, Texas. Attorney Richard Haynes was defending a man accused of a brutal home invasion. 3 victims. The evidence was overwhelming, but Haynes had defended worse. He was known as the lawyer who never quits. Then, during a private meeting, his client made a confession, not about the crime he was charged with, about 4 other murders nobody knew about. The client described them in detail, smiling the entire time. He told Haynes he planned to kill again the moment he got out. Under attorney-client privilege, Haynes couldn't tell anyone. But he also couldn't help this man walk free. So he did something unprecedented. He filed a motion to withdraw citing irreconcilable differences. The judge was suspicious. Lawyers don't abandon murder cases over differences. But Haynes couldn't explain without violating privilege. He was trapped. But here's where the system reveals its darkest flaw. The judge denied the motion. Haynes was ordered to continue defending a man he knew would kill again. Think about that for a moment. A lawyer, bound by law to help free someone he knows is a serial killer. This is the nightmare scenario they never teach you in law school. Haynes did something remarkable. He defended his client just well enough to meet his ethical obligations, but not well enough to win. The jury convicted. Some called it justice. Others called it the worst kind of legal malpractice. But Haynes knew something the critics didn't. Sometimes the system forces you to choose between your oath and your conscience. And sometimes, there is no right answer. This case set a precedent that would echo through courtrooms for decades. Case number 2 takes us to 2003, Miami, Florida. Public defender Maria Santos had been assigned to represent Carlos Mendez, accused of kidnapping his ex-girlfriend. Standard case. Until Santos visited the crime scene. There, hidden in plain sight, she found evidence the police had missed. Evidence that proved beyond any doubt her client was guilty. But that's not why she withdrew. Hidden with that evidence was proof that Mendez was planning another kidnapping. His next victim's photo. Her daily schedule. A detailed plan. Santos faced an impossible choice. If she stayed on the case, she'd be helping a predator target his next victim. If she revealed what she knew, she'd be disbarred and the evidence would be thrown out anyway. Fruit of the poisonous tree. She chose a third option. She withdrew and anonymously tipped off the intended victim. It cost her everything. Santos was eventually disbarred for violating attorney-client privilege. The woman she warned was never harmed. Mendez is currently serving 40 years. But here's the question legal scholars still debate. Did Santos do the right thing? The Florida bar said no. She broke her oath. She violated the sacred trust between lawyer and client. But that woman is alive today, because Santos chose a stranger's life over her career. This case established what became known as the Santos dilemma. When does the duty to protect innocent life override the duty to your client? Every law student in America now studies this case. And they all reach the same conclusion. There is no good answer. The system was never designed for situations like this. But the next case I'm about to show you, it makes the Santos dilemma look simple. But everything I've told you so far, the ethical nightmares, the impossible choices, that's just the foundation. Because case number 3 broke something in the legal system that has never been repaired. 2011, Chicago. Defense attorney Robert Shapiro, not the famous one, a different Robert Shapiro, was assigned to defend a man named Thomas Crane. The charge was first-degree murder of a child. Now, I need you to pay close attention here because what happened next has never happened before or since in American legal history. Shapiro showed up to court on day 1 of the trial, stood before the judge, and said these exact words. "Your Honor, my client has confessed to me that he is guilty, not just of this crime, but of crimes against other children that remain unsolved. I am withdrawing effective immediately." The courtroom erupted. Shapiro had just done the unthinkable. Shapiro had deliberately violated attorney-client privilege in open court. He had just ended his career in the most public way possible. He was immediately held in contempt. He would later be disbarred, fined $200,000, and briefly jailed. But here's what happened next. Because Shapiro's statement was made in open court, it became public record. Investigators used it to reopen 3 cold cases. 3 families who had spent years wondering what happened to their children finally got answers. Thomas Crane was eventually convicted of 4 murders instead of 1. He received the death penalty. The legal community was divided. Half called Shapiro a hero who sacrificed everything to protect other children. Half called him a traitor who destroyed the foundation of attorney-client trust. Shapiro himself said only one thing to reporters: "I sleep fine at night." Do you think Crane's previous lawyers do? Case number 4 proves that sometimes withdrawal isn't about ethics at all. It's about survival. 2016, Phoenix, Arizona. Criminal defense attorney Jennifer Walsh was representing Marcus Stone, a mid-level drug dealer facing distribution charges. Routine case, easy money. Then Walsh started receiving threats. Not from prosecutors, not from police, from her own client's associates. They wanted her to do more than defend Stone. They wanted her to smuggle messages to cartel members during prison visits. They wanted her to pass along names of informants. When she refused, they made it personal. Photos of her children at school, her husband's daily route to work, a bullet left in her mailbox. Walsh went to the police, but she couldn't reveal how she knew about the threats without violating privilege. The cartel knew this. They were using the very system designed to protect defendants as a weapon against her. I need to stop here and make sure you understand how trapped Walsh was. Let me put this in perspective. If she withdrew, the cartel would know she went to authorities. If she stayed, she'd become an unwilling accomplice to organized crime. If she revealed the threats publicly, evidence would be tainted and violent criminals would go free. There was no good option. None. Walsh made a decision that legal experts still study today. She withdrew citing personal medical issues. A lie. But a lie that gave her cover. Then she did something extraordinarily dangerous. She secretly cooperated with the FBI for 18 months while technically no longer being Stone's attorney. The result? 23 cartel members arrested. Her client Stone became a cooperating witness, and Walsh had to completely change her identity and relocate her entire family. She never practiced law again. Cases 5 and 6 happened within months of each other in 2019, and they revealed a pattern that should terrify every American citizen. 2 separate attorneys, in 2 different states, withdrew from cases for the exact same reason. Their clients weren't just guilty. Their clients had confessed to crimes that would have implicated powerful people. Politicians, businessmen, people with resources to make problems disappear. In Case 5, attorney David Chen in New York withdrew from a white-collar fraud case after his client revealed a bribery network reaching into city government. Chen received a visit from men who suggested his family might encounter difficulties if he continued. In Case 6, attorney Patricia Moore in California withdrew from an embezzlement case when her client named a tech billionaire as a co-conspirator. Her car was firebombed the following week. Both attorneys are alive. Both refused to discuss why they withdrew. Both of their clients died in prison under suspicious circumstances. And now, case number 7. The one I promised would change everything. 2022. The defendant was a sitting congressman. The charge was human trafficking. His defense attorney was a 30-year veteran named William Foster. Foster had defended killers, terrorists, the worst humanity had to offer. He had never withdrawn from a case in his entire career. Until this one. But Foster didn't just withdraw. He held a press conference. and he said something that shattered legal precedent. He said, "I have seen the evidence my client has tried to hide. I have heard what he's done to children. I cannot in good conscience let this man escape justice through legal technicalities. I am withdrawing, and I am waiving privilege." Foster was immediately arrested. He will likely spend the rest of his life fighting disbarment. But because of his statement, evidence that would have been inadmissible was suddenly public record. The congressman was convicted. 23 victims came forward. And legal scholars are now seriously debating whether the entire concept of attorney-client privilege needs to be reformed. William Foster knew exactly what he was doing. He calculated that his career, his freedom, his reputation were worth less than protecting future victims. And here's what makes this case so significant. Legal experts are now asking a question that hasn't been seriously considered in 200 years. Should there be exceptions to attorney-client privilege for ongoing harm to children? Foster's case has already been cited in 17 state legislatures considering reform bills. The American Bar Association has opened an unprecedented review. We may be witnessing the beginning of a fundamental change in how justice works in this country, all because one attorney decided that some secrets are too dangerous to keep. These 7 cases share one thing in common. Each attorney faced a moment where their oath and their conscience collided, and each one chose their conscience. Right or wrong, they remind us that the law is not just rules on paper. It's human beings making impossible choices every single day. Now you know what most people never will. That behind every attorney withdrawal is a story of impossible choices, hidden threats, and moral reckonings that the system was never designed to handle. If this changed how you think about criminal defense, subscribe and hit that notification bell because next week we're covering something even more disturbing. Judges who sabotage their own trials. But I want to know what you think. Of these 7 attorneys, who made the right choice, and who crossed a line that should never be crossed? Tell me in the comments.